Ladies and gentlemen, I would like to begin by expressing my sincere thanks to the Permanent Bureau of the Hague Conference for the opportunity to speak at this birthday event of the 1996 Hague Convention. A birthday means looking back and looking ahead. Looking back, I remember having great difficulty with the 1996 convention at one of my first international conferences on child protection. I couldn't make sense of the term 1996 Hague Convention at an English-speaking event because in Germany we speak of the Convention on the Protection of Children and don't mention a year. And besides, I didn't know it at all yet because it was not yet applied in Germany. It must have been before 2011 because the convention came into force for Germany on January 1st, 2011. So our first meeting was rather bumpy. In the time that followed, we became friends. I work at a family court where we have special jurisdiction with 2 judges for certain proceedings in the field of international family law for the entire district of our higher regional court. There are 9 million people living here, and it is very international, so we hear a lot of international family proceedings. These include proceedings concerning parental responsibility with an international component and child abduction proceedings under the Hague Child Abduction Convention, of which I have heard over 200 cases as a judge over the years. Here the question of unlawfulness requires clarification of the custodial situation at the time of the abduction. I have noticed that a considerable number of children have not only lived in one country before the abduction, but have often moved abroad with their parents several times before. These are often very international families for economic, professional, or even private reasons. Sometimes there are court decisions on custody. Mostly, however, it is a question of the legal situation according to the law, so that Article 16, Paragraph 3 and Paragraph 4 of the 1996 Hague Convention apply. These provisions repeatedly caused great astonishment among judges and lawyers in the context of training courses that I conduct. If the child's habitual residence changes rights of custody under the law of the former habitual residence continue to exist, even if they do not exist under the law of the state of the new habitual residence. Rights which do not exist under the law of the state of the previous habitual residence, but which do exist under the law of the state of the new habitual residence are added. The child therefore moves with a backpack in which he or she takes custody rights with him or her. Nothing is lost, only rights can be added. Parents are often not aware of this. Not are lawyers who are not specialized in this field. This is even more true in Europe, where crossing borders in the Schengen area has no preconditions of border controls. However, it is very important to know these rules as they determine the situation in relation to the child on the basis of the law. To these questions in abduction proceedings is also added another question, where the unliteral action of removing or retaining the child outside of the state of his or her habitual residence was lawful or unlawful. In my opinion, the general public should be made much more aware of these issues. These rules are also good. They protect the best interests of the children by preserving custody relationship in the event of removal abroad and by ensuring uniform application in the current 53 contracting states of the 1996 Hague Convention worldwide. Furthermore, in addition to the establishment of the central authorities, which significantly improve cross-border cooperation, I would like to emphasize the rules on recognition and enforcement in Article 23 following of the 1996 Hague Convention. By ensuring recognition and enforceability, the measures taken by the authorities of one contracting state retain effect in the other contracting state and can be enforced there after being declared enforceable. This also serves the best interest of the child. Measures do not simply lose their effect when the child moves abroad, but continues to apply if there is no reason for refusing recognition. This ensures continuity in the child's circumstances. I would now like to do what we practitioners love to do most, namely report on a case from this year I had worked on in my practice. I was involved in the case in my capacity as a deciding judge and also as a network judge in the International Hague Network of Judges. The course of this case shows very nicely how the 1996 Hague Convention ensures the best interests of the child and how direct judicial communication can help. The case takes place between Switzerland and Germany, which are both contracting parties to the 1996 Hague Convention. An unmarried German couple lived together in Switzerland, where their daughter was born in 2012. When the girl was 6 months old, the competent Swiss authority ordered joint parental custody. After the separation of the parents, the same authority, named Swiss Child and Adult Protection Authority, awarded custody of the child to the father in 2020 as a precautionary measure. In 2021, the child, now 8 years old, was in a very bad mental state. She claimed to have been beaten by the mother with whom she had contact. There was massive self-stimulatory behavior coupled with injuries. The child was verbally and physically aggressive and declared that she no longer wanted to live. The Swiss Child and Adult Protection Authority examined the child's situation and came to the conclusion that the girl's condition had to be further examined for a diagnosis in an inpatient diagnostic group. On March 1st, 2021, the Swiss authority issued a decision according to which, I now quote, the girl was to be placed in an emergency group of a youth welfare facility by cancelling the parents' right of residence until a final decision was made by the authority. However, the father prevented the implementation of the measure by taking the child to Germany without the mother's knowledge, shortly before the measure was issued, where he has been living with the girl ever since. The Swiss authority informed the German Youth Welfare Office about the situation, which took the child into care 2 days after the Swiss measure was issued. The girl was taken into a German youth welfare facility. The German Youth Welfare Office did not want to hand over the child directly to the Swiss authority because they were unsure about the legal situation. Significantly, custody interventions by an administrative authority do not exist in Germany, where such measures are reserved solely for family courts. The father was very aggressive there and demanded that the child be handed over to him immediately, as he was of the opinion that he was still entitled to custody in Germany. The Swiss authority applied to my court for a declaration of enforceability of its decision to place the child in a Swiss emergency group and to revoke the parental right of residence. The question of whether a foreign decision was not taken by a court but by an administrative authority is subject to the provisions of the 1996 Hague Convention, was clearly answered by Article 23 and Article 5 of the 1996 Hague Convention. It is a measure taken by an authority, whereby such authorities may be either judicial or administrative authorities. Decisions taken by the Swiss administrative authorities, which are competent to do so under Swiss law, are subject to the 1996 Hague Convention. The authority had also submitted all the documents required under the 1996 Hague Convention. I'm not familiar with Swiss national law, and it was difficult for me to know whether the decision was enforceable. On this question, I consulted my network colleague in Switzerland, Daniel Behler, who is the network liaison judge for Switzerland. The very next day, I had his answer. According to the case law of the Swiss Federal Supreme Court, provisional measures can't be challenged. He also explained to me in detail what exactly the enforceable content of this measure of the Swiss Administrative Authority was, which was unknown to me as a German judge. It was the not expressly titled surrender of the child to the administrative authority, which now had the right of residence determination. I concluded that there were no grounds for refusal under Article 23.3 of the 1996 Hague Convention. On March 12, 2021, that means less than 2 weeks after the measure was issued in Switzerland and only a few days after the application came in, I had all the information thanks to the smooth cooperation with the Swiss network judge. I declared the measure of the Swiss Administrative Authority enforceable in Germany, with an explanation for the German bailiff as to what exactly was enforceable. According to German law, an appeal against this enforceable declaration can be lodged within 1 month, which the father did. At that time, however, the German Youth Welfare Authority had already returned the child to the Swiss youth welfare authorities. They now considered the legal situation to be clarified on the basis of my decision and considered it urgently necessary for the welfare of the child that she was to leave the German youth welfare facility and be admitted to the Swiss inpatient diagnostic group where a diagnosis was made. The higher regional court, which dealt with the appeal against my decision, dismissed the father's complaint because it had been extinguished by the child's return to Switzerland. This case shows how the provisions of the 1996 Hague Convention ensured the continued validity and enforceability of the foreign measure in Germany. The network of judges made it possible for me to quickly obtain the necessary explanations on the context of the Swiss decision, so that I was able to order enforceability only a few days after the application was filed. The child was thus quickly able to receive the measure in Switzerland that she urgently needed for the restoration of her well-being. The 1996 Hague Convention ensured that the situation proceeded in an orderly manner. Now it remains to be hoped that the child is doing better in the meantime. The 1996 Hague Convention has done what it can to help her. To the 1996 Hague Convention, I say this: I wish the birthday girl all the best, and am sure that she will continue to ensure the welfare of the children across borders with her framework in the future. Thank you very much for your attention.